Hey guys, what's up? So we are continuing the discussion on important topics of Laxmikanth and we are dealing with chapter 23 to 29, and this is very important because you will know exactly what to read and what not to read. Till now we have covered the parliament. So this will finish the part 3 of, so this is chapter 23 to 29 and whatever you have to read in Laxmikanth. So chapter 23 deals with basically parliamentary committees. It is a very important topic. So meaning and classification of parliamentary committees, so that is important. Then public accounts committee, and it is one of the most important committees. It is asked in preliminary examination very frequently. So know its functions, compositions, assess its effectiveness, and in mains they can ask you a question on public accounts committee's performance and significance. Then you have estimates committee. So various functions of the estimates committee, composition, effectiveness of this committee. Now very important points that all the members are from Lok Sabha. It is also known as the Continuous Economy Committee. So that is related to the Estimates Committee. Then you have Committee on Public Undertaking. So various functions of it, compositions and effectiveness. Here notice that only Lok Sabha members can become chairman of this committee. So that is also important. Then you have basics of departmentally related standing committees, DRSCs. No need to memorize their name. Just try to get a basic idea. That's all that is needed. Now similarly for various committees to inquire, committees to scrutinize and control, various committees which are relating to the day-to-day business of the house, and housekeeping committees, and just try to underline their composition, basic functions, and just move on. Nothing much than that is needed. Then you have chapter number 24, which is parliamentary forums, and it is not an important chapter because not many questions are asked from this particular chapter. So you can speed read this chapter, you can completely ignore this chapter, nothing much important is there. But if you still want to read it, try to focus on the objectives, composition and functions of these forums. So that is important. Then you have chapter 25 as the parliamentary groups. So try to understand the rationale behind the Indian Parliamentary Group, IPG, then compositions, objectives and functions of IPG, and then skip the rest of the chapter. That is not at all important. Then there comes an important chapter which is the Supreme Court. So Supreme Court is an important chapter because it's a constitutional body. It is the highest judiciary body in the entire country. So try to understand the difference between Indian versus American judiciary, because in American judiciary like high courts and Supreme Courts are not in sync. So they are like the Supreme Court of USA is there, then Supreme Court of California is there. In India, like there is no Supreme Court of Rajasthan. Basically, Supreme Court of India is the highest authority, and High Court has like completely, utterly submersive to it. Then appointment of judges. Here read the controversy over the consultation. 3 judges cases are there. Evolution of the collegiate system, and the 4th judge cases and NGAC. Okay, National Judicial Appointment Committee. So there were a lot of issues related to that. Then qualification of the judges, tenure of judges, etc. Then understand clearly the procedure required for removal of judges or impeachment under the Judges Inquiry Act of 1968. So that point is also very important. Then provisions for ad hoc and retired judges. So that is also very important. And then independence of Supreme Court, how it is independent. It is a very important concept which you need to understand. So try to understand very well the need and provisions to safeguard and ensure the independent and impartial functioning of the Supreme Court. Then you have jurisdiction and powers of the Supreme Court. It is the most important part of this chapter. Original jurisdiction, appellate jurisdiction. Okay, there are various types of jurisdiction of the Supreme Court, so try to understand all of them. Then original jurisdiction, know the cases where it comes into the picture and the cases where it does not extend, so that becomes important. Then writ jurisdiction, like you have already read about it in the fundamental right chapter. Under Article 32, Supreme Court can issue 5 writs. So here compare the writ jurisdiction of Supreme Court under Article 32 with that of the High Court under Article 226. Then you have an appellate jurisdiction. So understand very well how the Supreme Court exercises this jurisdiction in various constitutional, civil and criminal matters and in special leave. Then you have advisory jurisdiction. So examine on which matters the President can seek the opinion of the Supreme Court under Article 143, and Supreme Court's obligation to either tender or to refuse to tender the opinion to the President of India. Then meaning of court of record, Supreme Court's power under it, meaning and consequences of contempt of court, so that is also an important part. Then various powers of judicial review which is given to the Supreme Court, and the list of 7 other powers of the Supreme Court are also given here. So these 7 other powers and list of the powers and powers of judicial review, all these are important topics, so please try to memorize them by heart. Then table 26.1 will compare the Indian and American Supreme Courts, so that table also becomes important because there is a stark difference between these two. Like American Supreme Court will take only very few cases, but Indian Supreme Court will take also mundane cases also. Now 3 categories of Supreme Court lawyers are there, so just get a basic info on that. That is all that is needed. And then you have chapter 27, which is judicial review. So the chapter of judicial review is very important from the mains perspective. So you have to understand the power of judicial review, how come a law becomes null and void, what is the mandate behind it, then meaning and evolution of this doctrine, importance of judicial review, then constitutional provisions related to the judicial review, then various scope of judicial review, to what extent can judicial review go, then comparison of Indian and American constitutional provisions which are related to the judicial review, then judicial review of the 9th schedule. So analyze Supreme Court's observation in Justice Koilo case on Ananda Bharti, Indira Gandhi cases, and note the final conclusion related to judicial review of the 9th schedule. That is, any case before the Keshavananda Bharti case, any act in there, it is beyond judicial review, but any act which is added after the Keshavananda Bharti case, that is 24th April 1973, Supreme Court can do the judicial review of that particular act. Then you have chapter 28, which deals with judicial activism. Now this is a very important chapter from mains perspective. So try to understand the meaning and evolution of this concept in India. Why is judicial activism required? Because legislature and executive are slow and they have left a power vacuum. Its relationship with public interest litigation, then rationale and justification of judicial activism, then what is the difference between judicial activism and judicial overreach, then trends in India which reflect the trend of this concept, various apprehensions. Okay, judicial activism, sorry for that. So you have judicial activism, judicial restraint. So just read Supreme Court's observation, which will give you further points in writing answer in mains. And then finally PIL, so evolution and meaning of the concept, features and scope of PIL, various principles evolved by Supreme Court in regard to PIL, guidelines laid down by the Supreme Court to prevent the misuse of PIL, and try to make the crisp notes and write answers of some mains question to get a grip. So thank you, we'll continue the discussion. Hey guys, what's up? So we will discuss chapter 30 to 33, and we have already covered the part 1, 2 and 3 of Laxmikanth, and these are the various important topics in polity, and this is the part 4 of Indian polity, and it has 4 chapters. Basically the chapter number 30 is governor, part 4 basically deals with the state government. So chapter 30 is governor, 31 is chief minister, 32 is state council of ministers, and 33 is state legislature. So these are the 4 chapters in the part 4, that is the state government. And in this lesson I'll tell you everything, all the important topics which one need to understand to cover these chapters. So chapter 30 is basically governor. So in this we will know what officials come under the meaning of state executive. So that is the first and the foremost thing, because they can ask you in UPSC which of the following officials are under the purview of state executive or not. Then second point is appointment procedure of governor. How does the governor of a particular state is appointed, rationale of the same, like why the governor is appointed, and which is given by the members of the Constituent Assembly. So that is related with the governor. Then obviously governor is a very big constitutional post, so you need to have certain qualifications which you need in order to become governor of a state, otherwise everyone can become. Various conditions to become governor and the terms of the governor's office, and here like there is no term as such, but he or she holds the office in the role of the on the pleasure of the president. So this phrase is oftenly quoted, that what do you mean by the pleasure of the president in case of governor's office. So just notice this line particularly, try to read around it and develop whatever you can regarding this. Then various powers and functions of the governor under 4 heads. So just on the lines of the president. It is almost same powers at state level, and try to notice the similarities and differences between various powers of president and governor. Okay, so basically, as the president is there at the union level, governor is there at the state level. So as the president is the head of the nation, governor is the head of the state, but there are various differences between the powers of the president and governor, and sometimes as a new aspirant, many of us are not well aware about these differences. So I will strongly urge you that you learn these differences. Then before you proceed further, like there are various tables which are given here in the state government, though this entire unit is not that important as compared to, let's say, unit 1, 2 and 3, but still study the tables 30.1, table 30.2, 30.3. So what these tables do is they compare the veto, ordinance making, pardoning powers of the president and governor, and it will highlight or underline the important differences. And finally, you can assess the constitutional position of the governor, provisions of article 154, because this is very important to know what are the constitutional powers that are given to the governor of a state. Then article 163, 164, then contrasting his constitutional position with that of the president, and what are the differences between these two posts. Then cases where the governor has a lot of constitutional discretion. So even more than the president of India, the governor enjoys a lot and lots of discretion, and he or she has a lot of discretionary powers, and they have also been used in theory as well as in practice. And also study some of the hidden discretions of governor. As I have told you, like despite the governor is much smaller than the president of India, yet the discretionary power of the president of India is slightly or somewhat less than the governor of a state. So these hidden discretionary powers are given to the governor, and they are derived from the basically exigencies of a prevailing political situation. So governor can become very powerful if certain political conditions align together. Then chapter 31 basically deals with the chief minister. So chief minister, just like prime minister, is the head of the government at the center level. So chief minister is the head of the government at the state level. He is supposed to make sure that the council of ministers is functioning properly and the things are being executed. So appointment procedure of the chief minister is very important. Role of the governor in the appointment of chief minister is again very important, because such questions are directly asked. Then term, salary, allowances are just like that of the prime minister. So these term, salary, allowances, all these are subject to change also. So just go through it fast, it is not that much important. Then powers and functions, like study chief minister's power in relation to the council of ministers, to the governor, and to the state legislature, and underline the institutions of which he is a chairman or member. So try to study like CM's power and in relation to council of ministers, governor, and the state legislature. Okay, and do a spatial analysis of chief minister's relationship with the governor, because this is a very peculiar relationship, and you should know the various out and out pros and cons of this relationship, and it is given under article 163, 164 and article 167 of the Indian Constitution. Then chapter 32 basically deals with the state council of ministers. So just like a union council of ministers, there is a state council of ministers as well, and it is the provisions are almost the same, almost ditto provisions are there, and as it is written, almost same provisions like those for the council of ministers at the center. So therefore you should speed read this chapter. Speed read basically means do not pay much attention to the detail, just go in a flow and revise and correlate the provisions for council of ministers at the center and in states. And constitutional provisions, try to study under article 163, article 164, article 166, article 167 and 177. Then it is very important to understand the nature of advice by ministers to the governor. So here the relationship between the governor, council of ministers is a bit different than that. The relationship between the president and the union council of ministers at the center is much different as compared to at the state level. So try to find out why this relationship is different, how it is different, what are the parameters which makes it different or same, etc. Then responsibility of the ministers, and you have to speed read, because by now you must have known the concept of collective responsibility, individual responsibility and no legal responsibility. So again, they are collectively responsible to the house, and there is no individual responsibility as such. And finally, read the role of cabinet and cabinet committees. at the state level, so they are also very very important for taking various important decisions. Then you have state legislature, chapter 33. So provisions are just like parliament, apply the same strategy here. So speed read if you are as if you are revising the chapter on parliament, and keep a very sharp eye on any differences. Then organization of state legislature. So memorize the names of the states with bicameral legislature. Okay, so you can remember it by Taj Kumbh. Okay, T A Telangana, Andhra, Jammu. Okay, Karnataka, UP, Maharashtra. Okay, Bihar. So these are the Taj Kumbh state. So role of parliament vis-a-vis creation, abolition of legislative councils, composition of assembly, delimitation of constituency, reservation of seats, etc. And it is give special focus on the provisions related to the legislative council, especially the manner of election of council members. It is important for duration of 2 houses, qualification disqualification process, vacation of seats, speaker, deputy speaker, just like the parliament. Speed read and other provisions like sessions, legislative procedure, again it is just like parliament. So thank you for watching this lesson. Hey guys, what's up? So here we are discussing the important topics of Laxmikanth and how we can go about reading all of them and in short amount of time, so that we are able to finish it in time, because it's a very thick book, and sir and ma'am, you need to do it very very fast. So this is chapter 34 to 37 and we are dealing with the part 4 of Laxmikanth. So let us get started. So part 4 is basically the state government. So it has the chapter 34 which deals with High Court. It has chapter 35 which is subordinate courts. Chapter 36 is special status of Jammu and Kashmir, and chapter 37 deals with special provisions for some state. All these are like relatively important chapters vis-a-vis some other chapters. So let us get started. So when we talk about High Court, so you more or less will find it is appointment of judges is the basic theme. The theme will be similar as compared to Supreme Court, but there is a huge difference. So appointment of judges, so you will have to read the judges case, including like there are first judges case, second judges case, third judges case, fourth judges case, and also the National Judicial Appointment Committee. Okay, so NJAC judgment is also there. Then who can become a judge? Can you become a judge? Can I become a judge? I can't become a judge because I don't meet the qualification to become a High Court judge. So what is this qualification? And tenure of judges, that is important. Then impeachment procedure, how a judge can be impeached, and it's similar to that for the Supreme Court judges, very similar. Then transfer of judges, third judges case, and so on and so forth. So this is basically the chapter 34 High Court. So and it also has, let's say, provisions for appointment of acting chief justice, additional and acting judges, retired judges, provision to ensure the independence of High Court. Then there are 7 types of powers and jurisdiction of the High Court. This is very very important. Okay, so similarly you will also have powers of Supreme Court and their jurisdiction, so that is also important, and this is also very important. Then you have chapter 35. So we are done with the chapter 34, that is the High Courts. Then you have subordinate courts. So here like a lot of MCQs are asked from this. So what are the appointment of district judges and qualifications which is required to become a district judge? Then appointment of other judges. So notice the trio here: governor, SPSC and High Court. So all these 3 are involved. Okay, State Public Service Commission, the governor and the High Court. So try to know the organizational structure, how it is structured, how it is organized. Then there is jurisdiction, what all they can pass judgment on, what all they can try in their court. Nomenclature of the subordinate judiciary. Okay, what are they called, and their names, and what are the judges called, and read about the basics of the NALSA, very very important. Okay, so there was an act in 1987 based on which NALSA was formed. NALSA is National Legal Service Authority. So while I was giving the prelims in 2013, there was a direct question from NALSA. Okay, and you also have SALSA. So SALSA is State Legal Services Authority. Try to read their main functions. Then there is also Article 39A. So NALSA, SALSA, their main functions, Article 39A, etc. So this is the subordinate courts. Then you have Lok Adalats, very very important. Okay, you should know everything about Lok Adalats. What is the meaning of Lok Adalat? Why were they formed in the first place? Because there is such a huge load of cases in Supreme Court, we had to make them provisions related to Lok Adalat under Legal Services Authorities Act of 1987. And if a question is asked in pre on Lok Adalat, it will be definitely from these provisions. So NALSA is also formed under Legal Services Authority Act of 1987. So read these provisions very, very carefully and notice the binding and the non-appealable nature of its award. Okay, it's binding on the parties and it cannot be appealed. And why do we need reasons for the establishment of permanent Lok Adalats? So this question is also important. Then reasons for the establishment of separate family courts, salient feature of the Family Courts Act of 1984, etc. And then salient features of the Gram Nyayalayas Act. Okay, Gram means village, Nyayalaya means it's a judiciary and court basically. It is very, very important, this Gram Nyayalayas Act. It is very, very important, especially for prelims. So you must know who appoints their presiding officer, and they will try all types of cases. They will possess powers of a civil court. They are not bound by the Indian Evidence Act of 1872. So this point is important. You'll have to remember such points. But they are guided by the principles of natural justice. Also, their awards are appealable, unlike those of Lok Adalat. So Lok Adalat, the award is binding and non-appealable. But here the awards are appealable, unlike the Lok Adalats. Then chapter 36, that is the special status of Jammu and Kashmir. So this is a very important chapter, especially in recent times it has become a lot of controversial. So in this chapter your main task is to compare the Indian Constitution with the state constitution. So this is very important, and focus on what provisions of the Indian Constitution applies to the Jammu and Kashmir and what provisions of the Indian Constitution do not apply to the Jammu and Kashmir. Obviously you know that Jammu and Kashmir is a separate constitution itself. So try to know the historical background of the state's accession to India, Maharaja Hari Singh, war with Pakistan, and then incorporation of Article 370 in the Indian Constitution. So all this background you should know at least. Then the provisions of Article 370, especially in the recent times, it has become a very, very hot topic and is a very debatable topic in the last few years. Analyze the present relationship between Jammu and Kashmir and India. So that is also important. And we are talking about mainland India. Obviously Jammu and Kashmir is a very integral part of India, but it's just like analyze the situation of Nagaland and India. So here we talk about Nagaland and rest of the India. Okay. So study the salient features of Jammu and Kashmir's constitutions. They have some features. Main recommendations of the group of interlocutors for J&K on matters of contention. So all these are important points. Then like question can be asked, to what extent is Article 370 of the Indian Constitution bearing marginal note like temporary provision with the respect to the state of Jammu and Kashmir is temporary. Basically, obviously it's not temporary, it is going on for last 70 years, but yet it is temporary, it can be taken away any day. But it has to be passed by Jammu and Kashmir's, like some people say it's constituent assembly, but that is not there anymore, so it is technically permanent. There are a lot of issues which you need to understand. Discuss the future prospects of this provision. So this was the main 2016 GS paper 2, and until and unless you have read this chapter well with proper analysis, there is no chance in hell you will be able to answer this question. Then you have special provisions for some states in chapter 37. So note the special provisions for Nagaland under Article 371A. So matters on which acts of parliament are not valid here. Special powers and responsibility of governor. On similar lines, study the special provisions of other states, mainly the northeast states. And if you are short on time, want to focus on other important chapters, read Nagaland and Sikkim and skip the rest of the chapter, that is not important. So I think and I hope that you have understood and learned the various important topics of these chapters, and it will help you to revise Laxmikanth in the shortest possible time. Thank you. Hey guys, what's up? So we are dealing with Laxmikanth chapter 38 and 39, and here I will highlight all the important topics of these chapters which one need to understand and remember, and you can leave the remaining topics of these chapters, because at the end of the day the time is the most valuable resource you have, and it is how you utilize the time that will determine the outcome. So we'll cover chapter 38 and 39. We have covered till now chapter 37. So this is the part 5. So part 5 basically deals with local government. It was not there in the original constitution, and later on it was introduced by Constitutional Amendment Act, and Panchayati Raj municipalities back-to-back Constitutional Amendment Act, okay, 73, 74. So this is the 38 chapter, and 39 deals with municipality. Both have similar role. One is in the rural area, one is in the urban area. That is the only difference, and obviously there are some differences. So when we talk about Panchayati Raj, so we'll deal with evolution of Panchayati Raj, and we'll start with the recommendations of so many committees are there. So many committees are there. Like you will need to know the recommendations, basic recommendation at least of Balwant Rai Mehta Committee, Ashok Mehta Committee, Rao Committee, Singhvi Committee. Again, it is important to know that you cannot remember all the recommendation. It is impossible. Humanly, it is not possible. Unless you have a Google or internet in your pocket, you cannot write down also in the exam hall. So as I am telling you, no need to remember all the recommendations, just the 3 to 4 most important ones will do. Then read the significance of 73rd Amendment Act. So that is also very, very important, the significance of 73rd Amendment Act. Okay. So then the composition of Gram Sabha, the 3-tier system of government, how does it function? Then the manner of elections of the members and chairpersons. So like directly for whom, indirectly for whom, how is the election is varied. Then reservation provisions, you might have heard that at least 1/3 of all the seats are reserved for women across the categories, and in some states like Rajasthan etc. it's even 50%. Then the duration, disqualifications, state election commission, okay, so it is not for state elections, it is for the election of the panchayat and the municipalities. So try to know its composition of the state election commission, functions of the state election commission, various financial tasks that can be assigned by the state legislature to the panchayats and how they can be empowered. Then static terms of reference of state finance commission, and notice that the state legislature decides its composition, qualifications, manner of elections of its members, unlike the central finance commission. So that is also important. Then application of the union territories. So note that the President of India may apply these provisions to any union territory whatsoever. Then exempted states and areas. So it is very, very important. Then it is many times it is asked in the MCQ type exams like SSC, Bank PO, etc. So try to memorize the name of the states and areas where these provisions do not apply. So it is very, very important. Okay, exempted states and areas where these provisions does not apply. And just get an idea of the 29 items under the 11th schedule. It deals with the Panchayati Raj. Obviously, it is impossible to remember all 29, but whatever you can relate with the village life. So if you are a villager, you will realize that these are the things that you will need to watch on a constant basis, and most of these items, they are important for local rural level, and the rationale behind putting them in this schedule is this. So all these things will be relatable to the village life. Similarly, the 12th schedule which deals with municipalities, you will be able to relate with the urban life. So all these points are absolutely clear. Then you have to deal with the list of compulsory and voluntary provisions. They are very, very important, and memorize the voluntary provisions, and you will be able to solve MCQs by elimination method. So you can memorize the voluntary provision, so compulsory are automatically left out, right? So if the MCQ asks, then you can solve it. Then PESA Act, okay, Panchayat extension to scheduled areas. So this act is also very, very important. It is important for prelims, obviously. It is important for mains. They can ask you to write a very short note on this. So study the objectives very well, features of this act very well, you have to study. Then financial power of the Panchayati Raj. So know the sources of finances, understand the financial problems of panchayats, and what is the main reason why are they not able to perform adequately as much as we want them to do. Then reasons for ineffective performance. So you must understand all the reasons listed here, meaning of the 3 F's. Systemic problems which plague the Panchayati Raj system, dependency on state government, and so on. So question like local self-government system in India has not proved to be effective instrument of governance. Critically examine the statement, give your views to improve the situation. So you have to agree with this statement, obviously, because it has not proved it. That is correct. So this was the very first question in this year's mains GS paper 2, and it can be answered pretty easily provided you have read the and revised this chapter very well, and if you make notes out of it, so you can know what are the reasons for ineffective performance and so on and so forth. Basically everything will be covered. Then you have the chapter 39, that is the municipalities. So there are 8 types of urban local governments in India, and there are central ministries that deal with the subject of urban local government, and then how the evolution of urban local bodies happened. So remember the Lord Mayo's and Lord Ripon's contribution in the British time, so that is important. Then various committees and commissions which are appointed by the central government to improve the functioning of urban local governments. You don't need to remember it, you can just skip it. Then 74th Constitutional Amendment Act, study its salient features well, most important part of this chapter. Then there are 3 types of municipalities, composition and manner of election of members of municipalities. Then there are provisions like reservation of seats, duration, disqualification, state election commission, power and functions, finances, state finance commission. They are all the same as that of the panchayats. So you can just do a speed read of this. No need to go in depth. Then district and metropolitan planning committees, just remember their composition and functions because that is the only thing that is going to be asked from you. Then go through the list of 18 items under the 12th schedule. Okay, municipalities. So just get the broad ideas about these items. You don't need to memorize them at all. Just like you did with Panchayati Raj, you will be able to relate to the city life. Then municipal corporation. So know the manner how they are established, composition of council, role of mayor, municipal commissioner, all this becomes very, very important. And municipality basically works in the same way as a corporation. So these points will become important for you. Then notified area committee reads its functioning. It is an entirely nominated body, neither elected nor statutory. Basics of town area committee. Cantonment board, know the provisions of Cantonment Act of 2006. It works under defense ministry. It is created and administered by central government. Then classification, composition, manner of election of members. Then read the basics of township, post trust, special purpose agency. And remember the 5 sources of income of the urban local bodies. This is important. Study the composition and functions of the Central Council of Local Government. So I hope you have learned whatever you need to read about the Panchayati Raj and the municipalities. Trust me, nothing more than this is required, and direct questions are asked in the prelims as well as the mains examination from this section. So thank you for watching this lesson. Hey guys, what's up? So we have finished the part 5 and we are discussing the part 6 and part 7. In this particular chapter, we will discuss chapter 40 and 42. Okay, so these are like the important topics of Laxmikanth which you need to understand, which you need to imbibe, and which you need to vomit out in the exam hall. So let us get started and let us try to cover all of them as soon as possible. So part 6 deals with union territories and special areas. So here chapter 40 is union territories and chapter 41 is scheduled and tribal areas. So I think that part is absolutely clear till now that we are talking about what we are talking about. Then you have the union territories here. So first of all, you need to know the creation of union territories, its historical background. So there is no need to remember the year of creation, but still if you can remember the rough year of creation, for example, when was Goa made a union territory and then it was made a state later on, Dadar Nagar Haveli and all these things, it will really help you a lot. When was Chandigarh existing? Basically when Punjab split into Punjab Haryana, so at that time Chandigarh was created. So basic information should be there because they can ask you in timeline type of questions, but you should know the reasons for their creation, why they are created in the first place. Now let us talk about administration of union territories. So the most important part of this chapter is this, that administration of duties. So understand how the president administers these union territories via an administrator. So administrator are usually IAS officers, senior bureaucrats, and then the extension of parliament's legislative powers to them, because it is technically territory of union. It is not a state, it is territory of union. So that is why parliament's legislative power will extend to them. There are some UTs like Puducherry and National Capital Territory of Delhi, so NCT Delhi. These are the regions which have their own legislative assembly also. Then there are presidential regulations, administration of acquired territories. So all these are important topics which are here. Okay, you should definitely know the reasons. Try to remember rough year also. Then special provisions for Delhi. As I have already told you, there was no legislative assembly in Delhi, but with the 69th Constitutional Amendment Act of 1991, the legislative powers of Delhi Assembly also came into being. So here you can note the strength of Council of Ministers is 10% and not 15%. So if you see all the legislative, okay, so and the ministers are usually 15% of Lok Sabha, 15% of legislative assemblies, but here you can see it is 10% and not 15%. Then powers of lieutenant governor, etc., because lieutenant governor is also there. Then study table 40.2, which basically do what is called as the comparison of states with the union territories. So what are the differences between state and union territories? What are the similarities between state and the union territories, etc., etc. Okay. So these things are important and you should understand them. Then you have chapter 1, which is scheduled and tribal areas. So that is there. So it is a small chapter, but it is very very important chapter, because especially in preliminary examination you will find a lot of questions from this. Now the president's power in regard to the declaration of scheduled areas is also very very important. Then you also have executive power of state and center, so that point is also important, so you need to understand these points. Then composition of tribal advisory council, extension of tribal advisory councils to states having scheduled tribes but not scheduled areas. So all these things, they are important, where basic MCQs can be asked from these questions. So especially from prelims perspective, do read chapter 41, scheduled and tribal areas. Then also various special powers of governor regarding the application of the laws of parliament in scheduled areas. So you will find a lot of special powers are given to the governor. Then 6 schedules, like the states for which it is applicable, AMTM. Okay, you can remember anything you like. So Tripura, Meghalaya, Assam, Mizoram, or AMTM, Assam, Mizoram, Tripura, Meghalaya. So just be careful that you do not include Manipur in this. Many people do this mistake because they remember M, so they tend to include Manipur in this. Okay, so rationale behind the sixth schedule is also very very important, that why sixth schedule is so and why the powers are there. Then you also have, let's say, various features of administration which are contained in the sixth schedule, like they can ask you what are autonomous districts, power of the governor of that state respect to these districts, composition and election or nomination of members of district councils, various matters on which these councils can make laws, application of acts of parliament to these areas, etc. So these are also something which you need to understand and which you need to realize and which you need to remember. Okay, so all these things becomes important. Then you have the part 7th, that is the constitutional bodies. So here there are various constitutional bodies which you need to understand. So 42 is election commission and Union Public Service Commission. Then chapter 44 is State Public Service Commission. Then you have the Finance Commission. Obviously there is no planning commission, so don't worry about it. Then Election Commission is a constitution. All these are constitutional bodies. So if UPSC asks which of the following is a statutory body, which of the following is a constitutional body, which of the following body is neither statutory nor constitutional, so try to remember all these names. Let's revise after me. Okay, Election Commission, Union Public Service Commission, State Public Service Commission, Finance Commission, National Commission for Scheduled Caste, National Commission for Scheduled Tribes, Special Officer for Linguistic Minorities, Comptroller and Auditor General of India, Attorney General of India, Advocate General of the state. So these are all the constitutional bodies and they lie in the part 7 of the constitution. So let us talk about Election Commission, chapter number 42. So article 324 has the offices of which Election Commission conducts the election. This is important, this you need to understand. Then comes the composition of Election Commission. So note that the conditions of service and tenure of office is determined by the president and not the parliament. This is a key point which you need to understand. Relationship between the chief election commissioner, the two other election commissioners, etc. All of these are very very important. Then various provisions under the article 324 to basically safeguard and ensure the independent and impartial functioning of the election commission. Do you know this is one of the few institutions which you can never accuse, nobody accuses them of, let's say, corruption or anything. These are the institutions which are responsible for free and fair election. Free and fair election is not easy to come by, sir and ma'am. You have to ensure the independence, impartiality, because this is the biggest institution. If this fails, then the entire things comes into the question. Then procedure for removal of the commissioners. So notice the flaws in these provisions. Example, no qualifications, no specified term, no prohibition on practice after retirement, etc. Okay. Then study all the powers and functions of the election commission under the three heads. Three heads includes administrative head, advisory head, and quasi judicial head. All of these provisions are very important. Try to remember all of them. And here details of Delimitation Commission Act is not given, but it is often asked in prelims. So you can Google the Delimitation Commission Act and note down its salient features. And finally, to end this chapter, get a basic idea of the guiding principles behind the functioning of the election commission. So guys, thank you for watching this lesson. Have an awesome day.